Welcome to the deep dive. We're taking on a really fundamental area today, contract law.
Yeah, absolutely essential stuff.
Think about it, so much of our daily lives, from grabbing a coffee to huge business deals, really relies on agreements. Contract law is, well, it's the essential rule book for making those agreements work.
Absolutely. And, for anyone just starting out in law, maybe heading into their first year, it can feel like a whole new world. There are these specific concepts, historical cases, and just a particular way of thinking about these agreements.
Exactly. So if you are about to dive into your law degree and you want a solid head start, you're definitely in the right place. Our mission in this deep dive is, well, to give you a clear, strong, and hopefully pretty fascinating grasp of the core principles of contract law.
And we'll be drawing on the classic legal textbooks as our guide,
Yeah.
the foundations upon which all contract law understanding is really built.
Right. So let's start at the beginning. What actually turns a simple agreement into something legally binding? That's where the formation of a contract comes in.
And it all begins, fundamentally, with agreement itself.
Okay, let's unpack this a bit. Agreement in contract law usually kicks off when one person makes an offer and then the other person accepts it.
Yeah, it's like the legal equivalent of two people shaking hands on a deal, essentially.
Now, what makes an offer a real offer in the eyes of the law? It's got to be a clear signal, hasn't it, that you're ready to be bound by specific terms.
Exactly. And this is where it can get a bit fuzzy sometimes, especially in ongoing chats or negotiations where people might just be, sounding things out.
Right, like saying, I'm thinking of selling my old bike for 50 pounds. That's probably just an invitation to start talking, an invitation to treat, as they say.
Precisely. That's likely an invitation to treat. But if you say, I offer to sell you my old bike for 50 pounds, that's a much more definite statement. That sounds like an offer.
Okay. And then acceptance. When someone receives that offer, their response needs to be a clear and unqualified yes to all the terms.
That's the key, unqualified. Lawyers sometimes talk about this as the mirror image rule. The acceptance has to perfectly match the offer.
No changes allowed.
Well, if you try to change any part of the deal, like the price or the delivery date, that usually isn't acceptance at all. It actually kills the original offer and counts as a brand new offer, a counteroffer going back the other way.
Right, like your bike example.
Yeah.
If someone offers it for 50 pounds, I can't accept by saying, okay, I'll give you 45 pounds. That's me making a counteroffer.
Exactly.
Now, the acceptance also has to be a direct response to an offer you actually know about, doesn't it? You can't accidentally accept something.
That's right. You can't accept an offer you are completely unaware of. There needs to be a conscious link, an intention to accept that specific offer, sometimes called a meeting of the minds or a consensus ad item. Yeah, there needs to be an awareness. There's this old case, Tin v. Hoffman, which kind of illustrates this. Imagine two people sending identical offers to buy and sell something to each other at the exact same time, but neither knows the other has sent their offer.
Like cross offers in the post.
Exactly, cross offers. The court said that just because the offers match up doesn't automatically create a contract. One of those offers still needs to be accepted by the other party after they become aware of it.
But that's interesting. So just because two people happen to want the same thing simultaneously doesn't mean they've got a deal. There has to be that offer followed by a knowing acceptance.
Precisely.
Now, how do you actually communicate your acceptance? Can you just, I don't know, think really hard about saying yes?
No, generally not. The general rule is you need to communicate your acceptance to the person who made the offer. Silence usually isn't acceptance.
Okay, you have to tell them.
But the law is often quite practical about how you do this, especially if the offer itself maybe suggests a particular way to accept.
Like reply by email.
Yeah, or send a written notice to this address. But unless the offer is really strict and says you must accept only in that specific way, using language like mandatory, then other methods that are just as clear and quick and don't disadvantage the offer can also be valid.
So a bit of flexibility there.
There is. There was a case, Manchester Diocesan Council, where the offer suggested sending acceptance to a specific address. But sending it to the offeror's surveyor was still considered okay because it effectively communicated the acceptance just as well.
That makes sense, practical. But there's a really famous exception to this communication rule, isn't there? Something about posting letters.
Yes, the postal acceptance rule. A classic. This is a key exception, definitely one to remember. Basically, if it's reasonable in the circumstances to accept an offer by mail.
Like if the offer came by mail.
Often, yes, or if it's just a standard way of doing business. Then acceptance actually takes place the moment you correctly address and stamp the letter and drop it in the postbox, not when the offer receives it.
Wow. Okay, hold on. So I post my yes, and bam, contract formed. Even if the letter gets delayed for weeks, or even gets completely lost in the post.
That's the rule. As established way back in Adams v. Linsell, and confirmed in other cases like household fire insurance, the offer is bound even if they never actually see the acceptance.
That seems, well, quite risky for the person making the offer. Why did the law develop like that?
It does put the risk on the offerer. The courts decided this partly to create certainty for the person accepting, the offeree, especially back when post was a primary and often slow means of communication. It means the offeree knows exactly when the contract is formed.
And it also means the offerer can't change their mind after the acceptance is posted.
Exactly. Once that letter is posted, the offerer cannot revoke their offer. There was a case, Byrne v. Van Tienhoven, that really highlights this. They sent an offer, then sent a revocation. But before the revocation arrived, the other party had already posted their acceptance.
So the revocation was too late.
Too late. The contract was formed when the acceptance was posted.
Incredible. It really shows you need to be careful about your offers and maybe specify how acceptance should happen if you don't want the postal rule to apply. What about if the offerer dies before the acceptance arrives or even before it's posted?
Generally, if the offer dies before acceptance, the offer lapses. It can no longer be accepted. The case Reeland touches on this. The offer essentially dies with the offer, particularly if the contract involves personal elements.
Right. Makes sense. You can't really be bound from beyond the grave in that way. Okay, so we've got offer and acceptance, that crucial link, the need for awareness. What if people sort of agree on the main points, but leave other important bits undecided? We'll sort out the details later.
That can be problematic. It can lead to what's called an incomplete agreement, and that might not be enforceable as a contract. If key terms, maybe the price, the subject matter, delivery dates are still up in the air or are just too vague.
Like a reasonable price.
Sometimes even that can be too uncertain depending on the context. If essential terms aren't settled, the courts might decide there was no real agreement in the first place. No true meeting of minds on what was actually being agreed.
So even if you've had positive discussions, if you haven't pinned down the crucial details, you might not have a legally binding contract yet.
That's a real risk.
No, okay, even if we do have a clear offer and a clear acceptance mirroring each other, there's another vital ingredient, isn't there? Something about whether the people involved actually meant it to be legally serious.
Exactly. This is the concept of intention to create legal relations. Just because you have offer and acceptance doesn't automatically mean you have a contract. The parties must also have intended their agreement to be legally binding, to have legal consequences if broken.
You wouldn't normally expect a casual promise between friends over dinner to be something you could sue over if they don't follow through.
Precisely. The law presumes that in social or domestic arrangements between family members or friends, there generally isn't an intention to create legal relations unless there's strong evidence to the contrary.
But in business deals,
In commercial or business contexts, the presumption flips. The law presumes that the parties do intend their agreement to be legally binding, unless they clearly state otherwise, maybe using phrases like subject to contract or binding in honor only.
and how do courts figure out this intention? Do they try and read people's minds?
No, definitely not. They look at it objectively. They ask,
Oh.
would a reasonable person, looking at all the circumstances, the words used, the context of the agreement, conclude that the parties intended it to be legally binding? They don't rely on what each person secretly thought because, well, that would be impossible to prove and could lead to fraud. Certainty is key.
Okay, the objective test again. Makes sense.
And related to this, sometimes an offer might just sort of expire if the situation changes drastically before acceptance. There was a case, Financings Ltd v. Stimson, involving an offer to buy a car on hire purchase.
Right.
Before the finance company formally accepted the offer, the car was unfortunately stolen and damaged.
Oh, dear.
The court said the offer had effectively lapsed because the underlying condition that the car remained in, basically the same state, was breached. The subject matter had fundamentally changed.
So the offer wasn't valid anymore. Okay, so I've got agreement, offer, and acceptance. An intention to create legal relations. What's the final piece of this puzzle for a basic contract, often called the price of the promise?
That's right. We're talking about consideration. This is another absolutely essential element for most contracts to be legally binding in common law systems like England and Wales.
Consideration.
The price.
Yeah, though price can be a bit misleading, it doesn't have to be money. A classic definition comes from the case Curry v. Misa. Consideration is either some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other.
Okay, so a benefit to one side or are a detriment to the other.
Exactly. Usually in a typical transaction, both are present. If I promise to sell you my textbook for £30.
The benefit to you is the £30. The detriment to me is paying it. The benefit to me is the book. The detriment to you is giving it up. Perfect. You've got benefit and detriment flowing both ways. But it doesn't always have to be like that. Sometimes the main element might be a detriment suffered by the person receiving the promise without a direct tangible benefit to the person making it, or vice versa. Cases like Jones v. Padavatten or Pellon v. Lau Yu Long explore these nuances. The key is that something of value in the eyes of the law must be given in exchange for the promise. It doesn't have to be adequate, just sufficient.
Doesn't have to be a fair price, just a price.
Generally, yes. Courts don't usually inquire into whether you made a good bargain, just whether a bargain was made.
Now, there's often debate about situations where someone promises to pay more for something the other party is already legally obliged to do, like a builder halfway through a job demanding more money to finish it on time. Is promising that extra money a good consideration?
The existing duty problem. This is a really tricky area. Traditionally, English law was quite strict and said no. Performing or promising to perform an existing contractual duty you already owe to that person is not good consideration for a new promise of extra payment.
Because you're not giving anything new in return for the extra money.
That was the traditional logic. However, this could lead to commercially awkward results. More recently, particularly following cases like Williams v. Rafi Bros, the courts have sometimes found consideration if the person promising the extra payment gets some kind of practical benefit from the other party finishing on time, even if technically they were already obliged to do so, as long as there was no duress or fraud involved.
A practical benefit, like avoiding a penalty clause in their own main contract.
Exactly, things like that. And interestingly, the New Zealand Court of Appeal, in a case called Anton's Trawling, took maybe an even more pragmatic approach. They suggested that if parties genuinely intend to vary their contract, like agreeing on extra pay, and there's no policy reason not to enforce it, like duress, then perhaps the variation should just be enforced without getting too hung up on finding technical consideration. They saw consideration more as a signal of intention to be bound.
That sounds like a potential shift, focusing more on the party's real intentions rather than just the strict benefit-detriment exchange.
It's an ongoing debate. Some academics argue we should maybe modify or even replace the doctrine of consideration altogether, perhaps focusing more on intention or using concepts like economic duress or promissory estoppel to prevent unfairness, or simply asking if there's a good reason to enforce the promise.
Fascinating. So the role of consideration is still evolving.
Definitely.
Okay, so we've built our basic contract, agreement, intention, and consideration. Looks solid. But wait, even a properly formed contract can sometimes be challenged or unwound, right? Let's move on to what can limit contractual liability, these vitiating factors.
Exactly. Just because you've ticked the boxes for formation doesn't mean the contract is automatically enforceable no matter what. Vitiating factors are things that might have existed at the time the contract was made that undermine its validity. Let's start with mistake.
Mistake. When one or both parties got something fundamentally wrong about the deal. Now, you mentioned earlier the objective test for figuring out the terms. So this isn't just about misunderstanding the terms, is it? It's more about mistakes regarding the background facts.
Correct. Mistakes about the terms themselves are often resolved by that objective approach, what would a reasonable person think was agreed. But we're now talking about mistakes affecting a party's reason for entering the contract, or a shared mistake about a fundamental aspect of the subject matter.
Like both thinking something exists when it doesn't.
Exactly. That's common mistake at common law. If both parties enter a contract based on a shared fundamental mistaken assumption, like the existence of the goods being sold, the contract might be void. The classic case is Couturier v. Hasty, where they contracted to sell a cargo of corn.
But the corn had already perished at sea and neither knew.
Precisely. The contract was void because the subject matter they were contracting about didn't exist. However, you have to be careful. Sometimes the contract might actually allocate the risk of the subject matter not existing to one party, like in the McRae case.
Okay. But for common mistake to void the contract, it has to be a really fundamental mistake.
Yes, very fundamental. The leading modern case, Great Peace Shipping v. Savlaris, established a strict test. The mistake must make the resulting situation radically different from what the parties believed they were agreeing to. It must relate to the essential substance or foundation of the contract, not just equality.
Radical difference. Okay, that's a high bar. What about mistakes about who you're dealing with? Mistaken identity.
Yes, mistake as to identity can sometimes void a contract, but again, the law is quite specific. There's a distinction between being mistaken about someone's actual identity, who they are, versus being mistaken about their attributes, like their creditworthiness or solvency.
So, thinking you're selling to company A when it's actually fraudster B pretending to be company A.
That could potentially be avoiding mistake, especially in written contracts where identity might be crucial, as seen in cases like Cundy v. Lindsay or Shogun Finance v. Hudson. If you only intended to deal with that specific person or entity and not the person physically present, if dealing remotely, the mistake might be operative.
But if you're face to face,
In face-to-face dealings, there's a strong presumption that you intend to contract with the person standing right there in front of you, even if they're lying about who they are. The mistake is often seen as being about their attributes, like creditworthiness, rather than their fundamental identity, making the contract voidable for fraud, but not necessarily void for mistake. This protects innocent third parties who might later buy the goods from the fraudster.
the void versus voidable distinction being important for third parties again. What if only one side is mistaken? Unilateral mistake.
Generally, if only one party is mistaken, the contract is still valid. You can't usually get out of a deal just because you made a bad assumption. However, equity might step in if the other party knew, or really should have known, about your mistake regarding the terms and basically snapped up the offer unfairly. That's seen in cases like River Lake Properties.
So if they knew you'd made a slip in your offer and took advantage.
Potentially, yes. Also, briefly, there's rectification. If the written contract document, maybe due to a typo, doesn't accurately reflect the actual agreement both parties reached beforehand, the court can correct the document.
Okay, fixing typos. And there was that other one. Non est factum. Sounds dramatic.
Non est factum, it is not my deed. It's a very, very narrow defense. It's for someone, often someone vulnerable, perhaps due to blindness or illiteracy, who signs a document that is fundamentally radically different in character from what they thought they were signing.
Not just different in its effect, but a completely different kind of document.
Exactly. And crucially, the signer must not have been negligent in signing it. The Saunders v. Anglia Building Society case really limited its scope. It's not enough just not to have read the small print. The misunderstanding must be profound.
Okay, a very rare defense. So mistake is one big vitiating factor. What's next?
Next up is misrepresentation. This is a big one too. It happens when one party makes a false statement of fact, which induces or persuades the other party to enter into the contract.
So not a mistake, but an actual false statement from the other side that makes you sign up.
Correct. And it's important to distinguish between a statement that becomes an actual part of the contract, a contractual term, and one that's just a representation made during negotiations, but doesn't become a term.
How do courts tell the difference?
They look at various factors. How important was the statement to the person entering the contract? Did they make it clear it was crucial? Cases like Bannerman v. White touch on this. Also, did the person making the statement have special knowledge or skill compared to the other party?
Like the car dealer example again.
Yes, if an expert car dealer makes a statement about a car's history, Dick Bentley, it's more likely to be seen as a term than if a private seller with no special knowledge says the same thing, Oscar Chess. Timing of the statement and whether the agreement was later put in writing without including the statement are also relevant.
Okay. And it has to be a statement of fact. What about opinions or intentions?
Generally, a mere statement of opinion isn't a misrepresentation unless the person giving the opinion didn't actually hold it or implied they had facts to back it up when they didn't. Similarly, a statement of future intention isn't usually a misrepresentation unless the person never genuinely had that intention when they stated it, as suggested in a Wales v. Wadham. Interestingly, statements of law used to be treated differently, but now they're generally treated like statements of fact for misrepresentation purposes.
So stick to facts. Be honest about opinions and intentions. Now, I think there are different types of misrepresentation depending on how culpable the person making the statement was.
Exactly. There are three main types.
Okay.
First, fraudulent misrepresentation, often called deceit. This is the most serious. It means the person making the statement knew it was false, or they made it without believing it was true, or they were reckless, just didn't care whether it was true or false. The classic case defining this is Derry v. Peake.
Deliberate lying or recklessness. Second, negligent misrepresentation. This is where the statement is made carelessly, without reasonable grounds for believing it to be true. This can arise under common law negligence principles, but more significantly, under Section 2(1) of the Misrepresentation Act 1967. That act makes it easier to claim for negligent misrepresentation.
So careless falsehoods.
And third, innocent misrepresentation. This is where the person made a false statement, but they genuinely believed it was true and, crucially, had reasonable grounds for that belief right up until the contract was made.
So an honest mistake, but still a false statement that induced the contract?
That's the idea.
Okay, so different levels of fault. What can you do if you've been induced into a contract by one of these misrepresentations? What are the remedies?
The primary remedy available for all three types is rescission. This means setting the contract aside, essentially unwinding it, and putting the parties back as much as possible into the position they were in before the contract was ever made.
Like hitting the undo button. Pretty much. But rescission isn't always possible. There are bars to rescission, for example. If you've affirmed the contract after finding out the truth, or waited too long, lapse of time, or if it's impossible to restore the parties to their original positions, impossibility of restitution, or if an innocent third party has acquired rights in the subject matter.
So you have to act fairly quickly and can't keep quiet about it once you know.
Correct. And importantly, for negligent and innocent misrepresentation, under Section 2 of the Misrepresentation Act, the court has the discretion to award damages instead of allowing rescission, if it thinks that's a fairer outcome.
Okay, so maybe keep the contract but get compensation.
Mm-hmm.
What about damages as a remedy in their own right? Can you get money compensation as well as or instead of rescission?
Yes, damages are also available, and how they're calculated depends heavily on the type of misrepresentation. For fraudulent misrepresentation, you can claim damages in the tort of deceit. The aim is to put you back in the position you were in before the misrepresentation happened, and you can recover all direct losses flowing from the fraud, even if they weren't foreseeable. It's quite generous, based on but-for causation cases like Doyle v. Olby and Smith-Newcourt show this.
So cover all the damage caused by the lie.
For negligent misrepresentation under Section 2(1) of the Act, the measure of damages is surprisingly similar to fraud, based on this fiction of fraud. You can claim for all direct losses unless the representer proves they had reasonable grounds to believe the statement was true. This is quite tough on the representer and has generated academic debate. For common law negligent misstatement, damages are based on reasonable foreseeability, like in regular negligence cases.
So the Act gives a stronger damages claim for negligence.
Generally, yes. For innocent misrepresentation, traditionally, you couldn't get damages, only rescission or potentially an indemnity for obligations necessarily created by the contract. But now, remember, the court has that discretion under Section 2 to award damages in lieu of rescission.
Okay, that's a complex web of remedies. Rescission, different types of damages depending on the fault.
It is. It requires careful analysis of the facts and the type of misrepresentation involved.
Right. Let's move on. What about duress? That sounds pretty straightforward, being forced into a contract.
That's the core idea. Duress makes a contract voidable if it was induced by illegitimate pressure. The pressure essentially overbears the will of the party, leaving them no practical alternative but to agree.
Illegitimate pressure. Does that mean illegal threats?
It can include unlawful threats, absolutely. Threats to the person, like physical violence, Barton v. Armstrong, or threats to damage or unlawfully seized goods, Astley v. Reynolds, Maskell v. Horner. But it can also include pressure that might be technically lawful but is still considered illegitimate in the circumstances.
Like what?
This is where economic duress comes in. It involves applying commercial pressure, like threatening to break an existing contract, unless the other party agrees to pay more or accept new terms. The key is whether the pressure was illegitimate. Was there bad faith? Did the victim protest? Did they have any realistic alternative? And whether that pressure was a significant cause inducing them to enter the contract.
So not just hard bargaining, but improper threats that leave you no choice.
Exactly. And the threat only needs to be a cause, not the sole or main cause for the decision to contract.
Okay. Similar, but maybe more subtle, is undue influence.
Yes, undue influence also deals with improper pressure, but it often arises from a relationship of trust and confidence, where one party has influence over the other and abuses that influence for their own benefit.
So not necessarily an overt threat, but exploiting a relationship.
Correct. There are two main types. Actual undue influence, where you can prove specific acts of improper pressure or coercion, and presumed undue influence.
Presumed. How does that work?
Presumed undue influence arises in two situations. First, In certain relationships where influence is automatically presumed by law, like parent-child, solicitor-client, doctor-patient, but interestingly, not husband-wife. Second, even if the relationship isn't one of those, if you can prove there was a relationship of trust and confidence in fact,
Okay, so a relationship of influence exists.
then if the transaction between the parties is one that calls for explanation, meaning it doesn't seem easily explicable just by the nature of their relationship, like a large gift or a disadvantageous sale.
Like it seems suspicious.
Exactly. If those two things are shown, relationship of influence and a transaction calling for explanation, then the burden shifts to the person who benefited to prove that they did not exert undue influence. They have to show the other person entered into it freely, perhaps after receiving independent advice. Key cases here are Royal Bank of Scotland v. Ettridge, Note 2, and Allcard v. Skinner.
So the presumption puts the onus on the stronger party to show fairness. And again, this makes the contract voidable.
Yes, voidable, not void. So again, innocent third parties who acquire rights for value without notice of the undue influence are generally protected.
Right. We're covering a lot of ways a contract can be, well, vitiated. What about unconscionable bargains? That sounds like just a really bad deal.
It's more than just a bad deal. Equity might step in to set aside an unconscionable bargain, where one party has imposed objectionable terms on another party who is in a position of serious disadvantage, and the first party has exploited that disadvantage unconscionably.
So, exploiting vulnerability, like someone who is very poor or ignorant or infirm.
Yes, those are classic examples of potential disadvantage. But it also requires the transaction itself to be improvident, really disadvantageous to the weaker party, and the stronger party's conduct in obtaining it to be morally reprehensible, something that shocks the conscience of the court, as put in the Alec Lobb case. It's a high threshold, not just about unequal bargaining power.
So a combination of a vulnerable party, a terrible deal for them, and morally wrong behavior by the other side.
That's the essence of it.
Okay. Finally, in this section on limits, we have illegality. Contracts that involve breaking the law.
Exactly. If a contract is expressly or implicitly forbidden by statute, or if it's contrary to public policy, like a contract to commit a crime, or one that unreasonably restrains trade, it's generally void and unenforceable from the outset.
Even if the parties didn't realize it was illegal.
Generally, yes. Ignorance of the law is usually no excuse here. The courts simply won't lend their aid to enforcing an illegal agreement.
And this applies both to contracts that are illegal in themselves and contracts that are performed illegally.
Yes, though the consequences can sometimes differ slightly. A contract illegal per se, like an agreement to bribe someone, is clearly void. If the contract is lawful on its face, but is carried out in an illegal manner, e.g. performing a transport contract using an unlicensed vehicle when a license is required, that can also render it unenforceable, particularly by the party responsible for the illegal performance. The Bowmakers case explored some complexities around recovering property transferred under such contracts.
So basically, stay on the right side of the law if you want your contract to be enforceable.
A very good principle.
Okay. One more area related to limiting liability within a contract exemption clauses and unfair terms. These are clauses trying to avoid responsibility if things go wrong.
Precisely. Exemption clauses, or exclusion clauses, aim to exclude liability altogether for certain breaches or events. Limitation clauses aim to limit liability, perhaps capping it at a certain amount. They are very common, especially in standard form contracts.
Like the small print on a ticket or a dry cleaning receipt.
Exactly. Now, the common law itself has some ways to control these. For instance, the contra preferentum rule says that if a clause is ambiguous, it will be interpreted narrowly against the party trying to rely on it to escape liability.
So if it's unclear, it works against the person who wrote it.
Generally, yes. There used to be a doctrine of fundamental breach, suggesting you couldn't exclude liability for a really serious breach that went to the root of the contract. But the House of Lords in Photo Production v. Securicor said it's really a matter of construction. Does the clause, properly interpreted, actually cover the breach that occurred, however serious?
So interpretation is key, but isn't there specific legislation to control unfair clauses now?
Yes, absolutely. This is crucial, especially for protecting consumers and small businesses. The two main pieces of legislation in the UK were the Unfair Contract Terms Act, 1977, UCTA, and the Unfair Terms in Consumer Contracts Regulations, 1999, although the regulations have now largely been replaced and consolidated into the Consumer Rights Act, 2015.
Okay, UCTA and the Consumer Rights Act, what do they do broadly?
UCTA primarily applies to business-to-business contracts and some non-consumer situations. It controls clauses that seek to exclude or restrict liability for negligence, and also liability for breach of implied terms in contracts like sale of goods or supply of services. Certain clauses are automatically ineffective, like excluding liability for death or personal injury caused by negligence, while others are subject to a reasonableness test.
Reasonableness. What does that involve?
The court looks at things like the bargaining power of the parties, whether the customer knew or should have known about the clause, whether the goods were made to special order, and whether it was reasonable to expect compliance with the term. It's a fact-specific assessment. UCTA doesn't apply to all types of contracts, though insurance, land contracts, and intellectual property are largely excluded.
Okay, so UCTA is mainly business liability and uses a reasonableness test. What about the Consumer Rights Act?
The Consumer Rights Act, 2015, particularly Part 2, which replaced the 1999 regulations, deals with unfair terms in contracts between a trader and a consumer. It applies a different test. A term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the party's rights and obligations under the contract to the detriment of the consumer.
Good faith and significant imbalance sounds broader than reasonableness.
It's generally seen as providing broader protection for consumers. Unfair terms in consumer contracts are not binding on the consumer. However, the Act doesn't allow a assessment of the fairness of terms that define the main subject matter or the adequacy of the price, the core terms, provided they are transparent and prominent. The OFT v. Abbey National case on bank charges wrestled with what constitutes a core term relating to price.
So consumer contracts get this unfairness test. And are there controls on clauses trying to exclude liability for misrepresentation?
Yes. Section 3 of the Misrepresentation Act, 1967, as amended by UCTA, says that any contract term trying to exclude or restrict liability for misrepresentation or the remedies available for it is only valid if it satisfies the UCTA reasonableness test.
So you can't easily hide behind a clause if you've misled someone.
No, the law provides significant protection there. And there's also specific legislation for other areas like consumer credit, product liability, etc. And just briefly, courts also use specific rules of interpretation for clauses trying to exclude liability for negligence, often called the Canada Steamship Rules, which require very clear language to cover negligence.
Okay, so lots of controls, especially for consumers, over clauses that try to limit or exclude liability.
Definitely.
Right, we've covered how contracts are formed, the problems that can undermine them, vitiating factors, and how liability can be limited within them. Now, how do contracts actually come to an end? Discharge of contract.
There are several ways a valid contract can be discharged, meaning the obligations come to an end. The most common and straightforward way is discharge by performance.
Both sides just do what they promised to do.
Exactly. If both parties fully and precisely perform all their obligations under the contract is discharged. Everyone's happy.
But what if the performance isn't quite perfect? Maybe a tiny defect.
This brings us back to the entire obligations rule we touched on earlier. Historically, the rule, seen in cases like Cutter v. Powell, was very strict. You had to perform your entire obligation perfectly to be entitled to payment.
Which seems really harsh if you've done 99% of the work.
It was often harsh. So the courts developed exceptions, most notably the doctrine of substantial performance. If a party has performed the contract, but with minor defects that don't go to the root of the contract, they may still be entitled to the contract price, minus a deduction for the cost of fixing those minor defects. Cases like Honey v. Isaacs and H. Cake & Co. Ltd. v. Lee illustrate this.
So if you've basically done the job, you should basically get paid less the cost of snagging. That seems fairer.
Much fairer in many situations.
What are other ways contracts end besides performance?
Well, the parties can simply agree to end it. That's discharge by agreement. They can mutually release each other from their remaining obligations, perhaps by entering into a new agreement to terminate the old one, which itself needs consideration, unless made under seal.
Okay, mutual agreement. What about when one side messes up?
That's discharge by breach. If one party commits a sufficiently serious breach of the contract, it may give the innocent party the right to treat the contract as discharged, meaning they are released from their own future obligations, and they can also sue for damages.
A sufficiently serious breach? How serious does it have to be?
It generally needs to be either a breach of a condition, a term considered fundamental to the contract, or a breach of an intermediate or innominate term that has consequences serious enough to deprive the innocent party of substantially the whole benefit they were intended to get from the contract. A breach of a mere warranty, a less important term, only entitles the innocent party to damages, not to end the contract.
Condition versus warranty, that distinction is key then.
Very key. Also, a repudiatory breach occurs if one party makes it clear, by words or conduct, that they will not perform their obligations or will perform them in a way substantially inconsistent with the contract.
Like saying, I'm not going to deliver those goods after all.
Exactly. When faced with a repudiatory breach or breach of condition, the innocent party has a choice. They can either accept the repudiation, treat the contract as discharged, and sue for damages, or they can affirm the contract, meaning they keep it alive, insist on performance if possible, and retain the right to claim damages for the breach later.
So they have a choice, end it or keep it going and claim damages.
Correct. And many contracts also contain specific termination clauses that spell out exactly under what circumstances, like certain types of breach or insolvency, a party can terminate the agreement.
Right, built-in exit routes. Now, what if something totally unexpected happens, completely outside anyone's control, that makes the contract impossible or pointless?
That's where the doctrine of frustration comes in. This is discharge by frustration. If, after the contract is made, an unforeseen event occurs, without the fault of either party, which makes performance of the contract impossible, illegal, or radically different from what was originally contemplated.
Radically different. That phrase again.
Yes, the test from Davis Contractors v. Ferrum is crucial. The event must cause a radical change in the obligations, so that performance would be fundamentally different from what was undertaken. If that happens, the contract may be automatically frustrated.
Automatically discharged.
Yes, frustration automatically brings the contract to an end from the moment the frustrating event occurs. The classic early example is Taylor v. Caldwell, where a contract to hire a music hall was frustrated when the hall burned down before the concerts.
Because the specific thing needed for the contract ceased to exist.
Exactly. But it's crucial to remember, it's not just about performance becoming more difficult or expensive. In Sakiraglu v. Nobly Thorol, the closure of the Suez Canal made shipping goods much longer and costlier. But the House of Lords said the contract wasn't frustrated because it was still possible to ship the goods around Africa. The fundamental obligation hadn't changed.
So more expensive doesn't count. What are common frustrating events then?
Destruction of the essential subject matter like the music hall, death, or unavoidable incapacity of a party where the contract requires personal performance, subsequent illegality if a law is passed, making performance illegal. Sometimes the non-occurrence of an event which was the foundation of the contract, like in Krell v. Henry, where rooms hired specifically to watch the coronation procession were frustrated when the coronation was postponed. Though, compare that with Herne Bay Steamboat, where a boat hired for cruising and viewing the fleet wasn't frustrated just because the naval review part was canceled. The cruising could still happen.
So you have to look at the core purpose of the contract.
Yes. Significant government intervention that fundamentally alters performance can also frustrate, as in Metropolitan Water Board v. Dick Kerr.
Okay. And when frustration happens, the contract just ends. What about money already paid or work already done? Does everyone just lose out?
Before 1943, the common law position was harsh. The loss lies where it falls, meaning money paid wasn't usually recoverable unless there was a total failure of consideration, fibrosa case. But the Law Reform, Frustrated Contracts Act, 1943, changed this significantly.
How did it change things?
The act allows for money paid before the frustrating event to be recovered, and money payable ceases to be payable. It also allows a party who has conferred a valuable benefit, other than money, on the other party before frustration to potentially recover a just sum for that benefit. And it allows parties to recover expenses incurred before frustration, up to the limit of any money paid or payable.
So it tries to achieve a fairer distribution of the losses caused by the unexpected event.
Exactly. It aims for a more just outcome than the old common law rule.
Okay. And very briefly, are there other ways contracts end, like operation of law?
Yes. Things like bankruptcy or merger of companies can sometimes discharge contractual obligations by operation of specific legal rules.
Right. So we've seen how contracts end. But what if one party doesn't perform properly, they breach the contract, and it's not discharged by frustration? What can the innocent party do about it? What are the remedies?
The primary remedy for breach of contract in common law is damages and award of money.
Compensation.
Yes, compensation. The aim of contractual damages is usually to put the innocent party in the position they would have been in if the contract had been performed properly. This is often called protecting the expectation interest.
So if I contracted to buy goods for £100 to sell on for £150, but the seller breaches, my expectation damages might aim to cover that lost £50 profit.
That's the basic idea, yes. You're compensated for the profit you expected to make. Sometimes, if expectation loss is hard to prove, courts might award reliance damages, aiming to put you back in the position you were in before the contract was made, covering wasted expenditure incurred in reliance on the contract. Occasionally, restitution might be relevant, focusing on gains the breaching party made, but expectation damages are the main goal.
Okay, expectation interest is the usual aim. Are there limits on what damages you can claim? You can't just claim for everything that went wrong afterwards, can you?
No, absolutely not. There are key limiting principles. First, remoteness of damage. Based on the famous case of Hadley v. Baxendale, you can only recover losses that either A, arise naturally, according to the usual course of things, from the breach, or B, were reasonably within the contemplation of both parties at the time they made the contract as a probable result of the breach.
So foreseeable losses, essentially.
Yes, losses that were reasonably foreseeable at the time of contracting. You can't claim for highly unusual or unexpected consequences unless the breaching party knew about the special circumstances that made those losses likely.
Okay, remoteness. What else?
Second, mitigation of loss. The innocent party has a duty to take reasonable steps to mitigate or minimize their loss. You can't just sit back and let the losses pile up if you could reasonably have done something to reduce them.
So if my supplier fails to deliver materials, I need to try and find an alternative supplier reasonably quickly, not just wait and claim for massive lost profits.
Exactly. You only need to take reasonable steps, not steps that are unduly burdensome or risky. And third, there's the issue of calculating the loss. Sometimes it's straightforward, like the difference in market value. Other times it's complex, like whether the damages should be the cost of fixing a defect, cost of cure, or just the difference in value between what was promised and what was delivered, diminution in value. The Ruxley Electronics v. Forsyth case about the swimming pool that wasn't deep enough explored this, sometimes awarding damages for loss of amenity instead.
Right. The cost of fixing might be disproportionate to the actual loss suffered. So damages are the main remedy, aiming for expectation loss, limited by remoteness, and the duty to mitigate. But sometimes money isn't really what the innocent party wants, is it?
True. Money might not be an adequate remedy, especially if the contract was for something unique. In these cases, the courts might grant equitable remedies, which are discretionary.
Like forcing the other side to actually do what they promised.
Yes, that's specific performance. It's an order from the court requiring the breaching party to carry out their positive obligations under the contract. It's typically granted for contracts involving unique subject matter, like the sale of a specific piece of land. Price v. Strange shows it's discretionary, because damages wouldn't allow you to get that exact piece of land elsewhere.
But not usually for personal services.
Generally not. Courts are very reluctant to order specific performance of contracts for employment or personal services, DeFrancesco v. Barnum, partly because it's hard to supervise and partly because it smacks of forcing people into relationships.
Makes sense. Any other equitable remedies?
Yes, an injunction. This is a court order requiring a party either to do something, a mandatory injunction, or, more commonly, not to do something, a prohibitory injunction, in breach of contract. For example, enforcing a valid non-compete clause.
Okay, stopping them from doing something wrong. And finally,
there's the straightforward action for an agreed sum, or action for debt. If the contract requires one party to pay a definite sum of money, like the price for goods delivered, and they fail to do so, the other party can simply sue for that specific sum. The rules on remoteness and mitigation don't apply in the same way to debt claims.
right, just claiming the money you're owed under the contract.
Exactly.
Okay, we're nearing the end of our deep dive. We've covered formation, problems, discharge, remedies. Are there any other sort of overarching concepts in contract law that someone starting out should really be aware of?
Yes, a couple of really important ones. First, the doctrine of privity of contract.
Privity. Sounds like privacy.
Sort of related in concept. The traditional common law rule of privity, famously illustrated in cases like Dunlop v. Selfridge and highlighted for its potential injustice in Biswick v. Beswick, basically says that only the actual parties to a contract can acquire rights or be subject to obligations under that contract. A third party, someone not involved in making the agreement, generally cannot sue on the contract or be sued under it.
So if A makes a contract with B, promising to pay money to C, C traditionally couldn't sue A if A didn't pay, even if the whole point was to benefit C.
That was the traditional, often criticized position. It could lead to results that seemed grossly unfair, as Lord Denning pointed out in Beswick, although Mrs. Beswick did succeed in her capacity as administratrix of her husband's estate.
That does sound unfair. Has that changed?
Yes, significantly. While the core doctrine still exists, the contracts, Rights of Third Parties Act, 1999, created a major statutory exception.
Ah, the act we mentioned briefly earlier.
Exactly. This act allows a person who is not a party to a contract, a third party, to enforce a term of the contract in their own right if either A, the contract expressly says they can, or B, the term purports to confer a benefit on them.
Purports to confer a benefit, so if the contract seems intended to benefit them.
Yes, provided the third party is expressly identifies in the contract by name as a member of a class or answering a particular description. However, the second limb, purporting to confer a benefit, doesn't apply if, on a proper construction of the contract, it appears the actual parties did not intend the term to be enforceable by the third party.
So the parties can still make it clear if they don't want the third party to be able to sue.
Correct. The Act gives third parties direct rights, but subject to the terms and conditions of the contract and potential defenses the original parties might have against each other. It's a really important reform.
Definitely sounds like it addressed a major gap. What about transferring rights you already have under a contract?
That's assignment. Contractual rights, particularly the right to receive payment or performance, are generally seen as types of property, chosen in action, and can be transferred or assigned by the party holding the right, the assigner, to a third party, the assignee.
So if someone owes me £1,000 under a contract, I can sell that right to collect the £1,000 to someone else.
Essentially, yes. There are legal rules for how this must be done to be effective, particularly for a legal assignment under the Law of Property Act, 1925. Needs to be in writing, absolute, with notice given to the debtor. If those aren't met, it might still be a valid, equitable assignment. However, you generally cannot assign the burden of a contract, your obligation to perform, without the consent of the other contracting party, though you might subcontract performance.
Okay, rights can be assigned, burdens generally can't without consent. One last concept: agency.
Yes, agency. This is fundamental to how much business gets done. Agency is a relationship where one person, the agent, is authorized to act on behalf of another person, the principal, to create legal relations, usually a contract, between the principal and a third party.
Like an estate agent selling a house for the owner.
Exactly. Or a company director acting for the company, or a solicitor acting for a client. When an agent acts within their authority and makes a contract with a third party on behalf of a disclosed principal, where the third party knows the agent is acting for a principal, even if they don't know the principal's name,
Then what happens?
then the contract is generally formed directly between the principal and the third party. The agent usually drops out of the picture and isn't personally liable on the contract, nor can they personally enforce it.
So the principal gets the rights and obligations.
Correct. Although there are exceptions where the agent might become personally liable, for example, if they act without authority, or if they contract on behalf of an undisclosed principal where the third party doesn't know they're acting as an agent, or by trade custom.
Okay, so the agent usually binds the principal, not themselves.
That's the general rule.
Well, that was a truly deep dive into the core principles of contract law. Wow. We've covered an enormous amount, really, from the initial offer and acceptance right through formation, vitiating factors, discharge, remedies, and these key concepts like prividity and agency.
We certainly have. And hopefully this overview gives anyone starting their legal studies or just interested a really strong foundation. Understanding these basic building blocks offer acceptance, consideration, intention, and how things can go wrong or be resolved is absolutely key for navigating the world of law.
Yeah, I can see how this would be incredibly helpful as you, the listener, explore more specific legal topics later in your degree. You'll see these principles cropping up again and again.
Absolutely. It provides a framework for understanding so much else.
So perhaps a final thought for you to take away. As you go about your day, just start to notice how contract law shapes pretty much everything around you. From the terms and conditions you click agree on, to buying a bus ticket, to your employment agreement, maybe even huge international trade deals you read about.
They're all built on these foundations.
Exactly. These contractual relationships are like the invisible threads holding so much of our society and economy together. So start observing and maybe analyzing the agreements you encounter. You might be surprised how often these principles we've discussed today come into play. Thanks for joining us.